Please, Your Lordship. I beg to mention item number 6, my lord. It's an appeal, my lord. It's been listed for the first time. I'm begging for adjournment for the day, my lord. On behalf of my senior Mr. M.K. Chaudhary. The matter can be fixed as per.
Admission matter.
I understand, my lord, but there's one matter that might take the majority of the day, my lord. It's of some difficulty today, my lord, to conduct the matter. Any
It
day,
is ordinary to be admitted.
understand, my lord, but.
Okay, on the prayer of Mr. M. Sharma and Council. Appearing for
Yeah,
appellant. Release the case is possible for
my lord, any day except for 17, 18.
release the case in the next week.
Please, Your Lordship. Beg to mention item number 15, my lord.
Yes,
Can it be passed over for the day, my lord? I'm some personal difficulty. I have to.
Mr. and Rekan, the Michael Security appearing for the ambulance. As we declare for adjournment. Of it. On the ground. His personal difficulty to do. Miss Biglia, and she has an additional opportunity to. Appeal for response checked as subject to the state as well. We should proceed with.
After the vacation.
Possible for a day.
Wait, Your Lordship. Lordship, with regard to item number 11 and 17, I'm making a mention on behalf of Mr. J. Das, Lordship. He's not well, undergoing treatment for cancer.
11. Insert it.
Lordship. It may be posted after the vacation, both these two methods.
Miss M. from
M.
Devi.
Devi, Lordship.
M. Devi. Direct counsel. Appearing on behalf of Mr. Zedas. Learned Michael Security at 11. For the appellant. As met. Prayer for adjournment of the appeal. And submitted that the appeal be listed after police. Post of the submitted by MDB. LDB. That Mr. Das. Is undergoing treatment.
After the vacation, Lordship.
Undergoing treatment
Lordship.
present. Miss. Yeah. People. National Consultation about Secretary Quarters, have submitted that state nomination to the fair by Germany in view of the ground cycle. Mr. Praying allowed, raise the case after 4 weeks. On the date to fix by the office, similarly 17.
Thank you.
May I thank you, Lordship? Lordship, I beg to mention item number 9 on behalf of P. Mohanto. Kindly adjourn the matter. P. Mohanto's father has expired. Kindly list the matter after 3 weeks.
Okay. Yes, Ms. Bhaiya, for what, for why, for what reason this has come? Madam, you'll be there, we'll find out. It will be adjourned, but if it is to be expedited in some manner, we'll pass an order.
Please, one IA, my lord, in the criminal appeal number POXO, my lord. Notice was issued from PP on 26/3/2025, my lord, the more than 2 months elapsed, my lord. That no report has yet come, my lord. If necessary, I will take fresh steps, my lord.
It is listed.
Late date next week, my lord, at any date. 11.
Order.
Very list for admission. Item number 1.
Three zero two.
302.
Heart, destroy and that. Learned, unlike a script what happened, and as S.H. Bora. Learned, additional public prosecutor for the Western State Poster. This criminal appeal is preferred against state judgments and orders
11/1/2024.
dated 11/1/2024, passed by the Court of Planet Session Judge Ibahagor in Sessions, case number 75, within bracket S of 2022. So by the judgment and order dated 11/1/2024, the accused appellant has been convicted under section 302 I, Indian Penal Code, and he has been sentenced to undergo rigorous imprisonment for life and to pay a fine of rupees 5,000, in default of payment of fine, to undergo simple imprisonment for another 3 months. First up, we have, and the appeal is admitted for hearing. The case records of Sessions case number so and so is are to be called for. Issue notice returnable in 4 weeks as Vora. The additional proposal will appear and accepted notice on behalf of the corresponding state to come issues of notice as dispensed with, place the case of the courts.
Item 2.
Dr. V.N. Gogoi, amicus for appellant S.H. Bora, additional public procedure for the respondent state. He has been in order dated 17/6/2023. Court of Learned Additional Session Judge comes Special Judge Boxo case.
Lordship.
Okay.
Under section 6 of the POSCO.
Boxo, Kamrup, Metro,
Lordship.
at Guwahati in Sessions case number 110 of 2021, arising out of Dispur Police Station case number 2040 of 2018. By the judgment in order, dated so and so, the accused appellant has been convicted for the offense under section 6, prevention of children from so and so, and he has been sentenced to undergo rigorous imprisonment for life and to pay a fine of rupees 10,000 for in default of payment of fine, to undergo simple imprisonment for another 6 months. So the appeal is admitted for hearing. The case records of POXO Sessions case number 110/2021 are to call for issue notice returnable in 4 weeks as Ms. Bora, additional prosecutor has appeared and accepted notice on behalf of the respondent number 1, the state of Assam, the issuance of all case is dispensed. The state responding is dispensed. Steps for service of notice upon the respondent number 2 of the informant is to be taken, are to be taken in terms of the practice directions with suspension. The additional public prosecutor is to obtain a report as regards service of notice upon the respondent number 2 as informant from the officer in charge jurisdiction and Dispur Police Station by the next state police. Is the case of the courts.
Item 3.
Also,
POSCO.
aid her, amicus curiae. For the appellant. S.H. Bora. Judgment. An order dated 17/3/2023. Court of Additional Session Judge, comes Special Judge, POXO, Kamrup Metro. At Guwahati. Sessions case number 18 of 2022. Arising of Sonapur Police Station case number 48 of 2019. Section 6 POXO, rigorous imprisonment for 25 years to pay a fine of rupees 10,000. In default of payment fine, to undergo simple imprisonment for another 6 months. So appeal admitted, case record call for, issue notice, Bora accept notice, practice direction for the service of notice, service report from the officer in charge, Sonapur Police Station. You want notice in the other one? I yes,
There is no I.
okay.
Item number 4.
May it please your lordship. Lordship, may I pass over for time, please?
So, Mr. Basu, will issue notice. Hard miss.
Lordship, in this matter, my senior colleague appear as a legal aid counsel, Lordship.
Good enough. Okay. Hard. The legal aid counsel for the appellant, accused appellant, and Mr. S.H. Bora, an additional public prosecutor for the respondent number 1, State of Assam. this criminal appeal under section 415 within bracket 2 Bharatiya Nagarik Suraksha Honita 2023 is directed against a judgment dated 29/1/2025 and an order on sentence dated 30/01/2025 passed by the Court of London Special Judge within bracket Poxo Kachar as Silsor. Case hold special within bracket Poxo case number 41 of 2023 arising out of Udarban Police Station case number 169 of 2022. By the judgment and order on sentence commander accused appellant has been convicted for the offense under section 366, Indian Penal Code IPC, and also under section 376D, IPC, as well as under section 6, POXO Act. Full stop. For the offense under section 366, by accused appellant has been sentenced to undergo rigorous imprisonment for 10 years and to pay a fine of rupees 10,000, with default stipulation. Full stop. In view of section 42, POXO Act, the accused appellant has been sentenced under section 6, POXO Act, and the sentence is to undergo rigorous imprisonment for 20 years and to pay a fine of rupees 10,000 with default stipulation. No sentence has been awarded under section 376D IPC. The sentences are ordered to run concurrently. We have gone through the contents of the memorandum of appeal. The criminal appeal is admitted for hearing. The case records of special POXO case number 41 of 2023 are to be called for. Issue notice returnable in 4 weeks. As Ms. Bora appeared accepted. Respondent 1, State of Assam. The accused appellant shall take steps or service of notice about the respondent number 2 best information in terms of the practice direction. The line addition of the procedure is to obtain a report. As a service of notice, I will ask number 2 informant from the officer in charge. Udarban Police Station case number by the next element. Yes, please the case up.
Lordship, IA is there.
Heart. The make the security for the applicant appellant. And Ms. S.S. Bora, learned additional prosecutor. For the opposite party number 1, opposite party the suspect number 1, State of Assam. This application under section 430 BNS SS is preferred seeking suspension of execution of the sentence passed against the applicant appellant and for his release of bail. Also, the applicant as the appellant has preferred the accompanying criminal appeal number so and so against the judgment and order date so and so. Last eligible. After that, practice direction of the steps. The state shall file its objection on or before the next set of list. Objection.
5.
POXO.
POXO 20 years imprisonment, my lord.
R.P. Sharma as hearing of the state by Miss E. Deca.
Ankita Deka.
For the accused appellant. S.H. Bora. Addition from prosecutor. For the respondent number 1, State of Assam. Appeal 415. I think it is not 4, it is 2. 415, we need to get 2. BNSS is preferred against the judgment and judgment and order dated 8/5/2025, passed by the Court of London Special Judge Poxo Vishwanath at Vishwanath Sarili in special within bracket Poxo case number 01 of 2021, arising out of Sotia Police Station, case number 01 of 2021, by the judgment and order dated so and so. The accused appellant has been convicted for the offense under section 4 within bracket 2 POXO Act, and he has been sentenced to undergo rigorous imprisonment for 20 years and to pay a fine of rupees 15,000, in default of payment of fine, to suffer rigorous imprisonment for another 3 months. We have gone through the contents of the memorandum of appeal. The criminal appeal is admitted for hearing. The case across of so and so case number be called for issue notice, returnable 4 weeks, as Ms. Bora has appeared accepted for the respondent one for state of Assam, issuance of formal notice to the respondent one is dispensed with extra copy of the memo of appeal. The accused appellant is to take steps for service of notice upon the respondent number 2 as informant by in terms of the practice direction. The line tradition of public prosecutor is to obtain a report as a service of notice upon the respondent number 2 as informant from the officer in charge. Sotia
yes.
Sotia presentation on or before
There is IM.
by the next date of listing. Post of
There is
Mr.
IM.
Sharma, Land Council, Senior Counsel, estate by Ms. A. Deca, Land Counsel for the applicant appellant. Ms. S. H. Vora, Land additional public prosecutor for the opposite party, the respondent number 1, state of Assam. This is an application under section 430 within bracket 2, BNSS. Seeking suspension of execution of sentence passed against the applicant appellant and for his release on bail. The applicant as the appellant has preferred the accompanying criminal appeal against the judgment in order to so and so. By the judgment in order to so and so, he has been sentenced to so and so. Issue notice returnable in 4 weeks. Same steps. The line additional public prosecutor is to obtain file his objection to the instant application by the next date of this. We consider after LCR.
Hello?
After LCR will be TCR, not LCR.
And Manoj,
Yes,
thereafter,
sorry.
I think paper book will have to be prepared in this case. Paper book.
After that only.
Yes.
After LCR only.
It's,
Sorry, TCR.
Item number 7.
An appeal against conviction under 302.
Okay, if you admit only first. Part, Mr. P. Gusami, Senior Counsel, estate by Mr. P. Jedotto, Land Counsel for the accused appellant and Ms. S. H. Bora. Additional for public solution for respondent state. Respondent number 1 state. First one. The instant criminal appeal. Now BNSS. 415. BNSS is preferred against a judgment dated 5/11/2024 and an order on sentence dated 11/11/2024 passed by the Court of London Sessions Judge Soraidev at Sunari in sessions within bracket CHA case number 212 of 2010. How many appellants? Appellants.
2 appellants.
Appellants.
Page 2.
Appellants. By the judgment and order on sentence, the 2 accused appellants have been convicted for the offenses under section 302 and section 201 of the Indian Penal Code, read with section 34 IPC. First one. Both the accused appellants. Where is the sentence?
My lord, your lordship will find that at page 19,
90,
191
1,
in the form C. In the second last column, my lord.
otherwise running page in the second part,
Page
conviction.
19,
Conviction.
lordship has that. May I read it?
Okay, what the accused appellants? For the offense under section 302-34, comma, IPC. Both the accused appellants have been sentenced to undergo imprisonment for life and to pay a fine of rupees 10,000 each with triple stipulation. Post one. 201, how much?
3 years, man.
For the offense under section 201 IPC, comma, both the accused appellants have been sentenced to undergo 3 years. Both the read with section 34 IPC. And they have been okay. Both the sentences are ordered to run concurrently. First of, we have gone through the contents of the memorandum of bail. The criminal appeal is admitted for hearing. The case records of so case number we call for. Are to be called for. Issue notice returnable info which as Ms. Poda. Respondent 1, State of Assam. The accused appellant shall take stage for service of notice upon the respondent number 2 by registered post KD within 3 working days from today. Place the case out of course.
Deeply of that.
You have any notice? Okay,
I also.
heard Mr. P. Goswami, line additional, sorry, line at senior counsel, is sent by Mr. P. J. Ratto, line counsel for the applicants appellants. And Ms. S. H. Boda, additional public prosecutor for the opposite party, that's respondent number 1, State of Assam. There is an application under section 430 P and SS seeking suspension of execution of the sentence passed against the appellants, and for their release on bail. The applicants, as the appellants, have preferred the accompanying criminal appeal number so and so against the judgment and order date so and so. We can look it up. Issue notice.
Deeply of that.
State to file objection. Huh?
Item number 8.
PK Das
Yes, Lordship.
for the
Appeal against Lordship judgment. dated
conviction,
34/2020.
conviction, right?
Yes, conviction.
3 appellants.
3 appellants.
By accused appellants. S.H. Bora. Learned additional public prosecutor for the respondent stage. 415 Union Bracket 2 BNSS 2023 against a judgment in order dated 30/04/2025 passed by the Court of London Sessions Judge Corporation. In Sessions case number T1/06/2019 by the judgment and order dated so and so. The accused appellants have been convicted for the offense under section 302 IPC, read with section 34 IPC, and they have been sentenced to undergo imprisonment for life and to pay a fine of rupees 10,000 each, in default of payment of fine, to undergo rigorous imprisonment for 6 months since. We have got to the conference of memorandum of appeal. The criminal appeal is admitted for hearing. The case records of session case number so and so are to be called for. Issue notice returnable in so and so as Ms. Bora has appeared accepted respondent of state. issuance of formal notice, dispensary, please take his proposals.
We have I also.
All right, Mr. P. K. Das, learned counsel for the applicant appellant. Ms. S. H. Bora. Is an application of section 450. BNSS seeking suspension of execution of sentence passed against the applicant's appellants and for their religion bill. The applicant says the appellants have preferred the accompanying criminal bill. Issue notice state file. Next bill.
Deeply obliged.
For orders, item 9.
Oh. Yes, sir.
Records. So issue as to the service,
Huh?
issue as to the service office.
Notice,
Of the 25.
neither regard.
That-
So,
that-
madam,
that
you
was-
take tips, this is a jail appeal. Jail appeal. It looks like jail appeal. Looks like jail appeal. POXO,
Notice are issued by registered post.
that is why.
States,
registry will hand over,
yes.
police station.
Sarpangpuri.
Miss
Sarpangpuri. D. Hazarika.
D.
Hazarika.
Hajarika, learned counsel for the learned counsel appearing for Miss H. Chakraborty, learned legal counsel.
P. Mohanta and H. Chakraborty.
Oh, we cannot record all. Is it legal aid counsel or what?
Probably not that.
Huh?
Personal, first, private, private.
Oh, private, then they have to
They
take
take-
steps. For the appellant. And Miss B. Bhuyan, learned senior counsel in addition, public prosecutor, assisted by Miss R. Das, learned counsel for the respond number 1, state of Assam. Peruse the office note dated 20/03/2023. Postal. As the appellant has been convicted under section 376 AB, IPC. Convicted under for the offense under section 6 and section 6 POXO Act. In addition to for the offense of murder under section 302 IPC. The appellant shall take steps for service of notice upon the response number 2 that's informant in terms of the practice direction. Date is so and so, so and so. The learned additional public prosecutor shall make endeavor to obtain a report as regards service of notice from the officer in charge,
Sarpangpuri.
Serpanguri Police Station, by the next date of listing. List the case after 4 weeks.
Number 10.
May I please, your lordship?
Yes.
It's come up for, IA is come up for consideration of bail and suspension.
Objection file.
Not yet.
Paperwork is ready.
Paperwork are ready. Hearing.
Age is proved.
Otherwise, lordship, there are some contradictory views.
Is
that-
by birth certificate or by ossification?
No, lordship, this is not birth certificate. This is 302.
Okay, 30.
302, but there are some contradictory views of the PWs. Some has said that in some other place, some
Okay,
has
so-
said, so it may not be a
Case
case
of direct evidence or indirect evidence?
direct evidence.
Direct.
Yes. lordship. There are
Better to have this.
there are two eyewitnesses in the case. But
Consistent or
per-
not consistent?
There, in little bit there are.
Prima
some
facie.
Yes, prima facie there is, prima facie there is.
Prima
Because
facie.
the father's version is some other, and there is his uncle in whose courtyard the body was lying.
And
Yes,
autopsy doctor, homicidal.
yes, that is-
Homicidal.
yes, yes.
State is to file objection, there are two options. You press for IA or press for appeal. Appeal is ready. Your private counsel,
No, lordship, I am appearing as a legal aid counsel in the matter.
private counsel, I can understand you can place for IA.
Yes, Lordship, it may come up for final hearing.
Ah.
No issue, Lordship. Because for I think it will not be a case.
Otherwise, you do not want to keep this pending. IA. You do not press, we can close. We can fix a date. Since when you were under, for
Lordship,
what period?
since 2 years, 5 months, 14 days.
Immediately the list
Lordship,
to be prepared on the 14th of July.
15th of June.
We can put it because the practice is that from the hearing list, it is put in
Yes,
the
yes.
daily list. Okay. Okay, I heard Mr. I'll you should let it. Legal counsel,
Legally transferred.
legal counsel for the applicant applicant. And Ms. S.H. Bora. Learned additional prosecutor for the party, Kama State or some. Those. We can close this by
Lordship.
our observation then,
Lordship.
instead of,
Lordship. Otherwise, I have read the case. There is, I think, no such case.
50-50.
50-50, Lordship.
Okay.
There are some witnesses. There are contradicting view of
Okay.
some witnesses.
This application under section 4. 89. Code of Criminal Procedure. 1973 speaker seeking suspension or execution of sentence passed against the applicant appellant and for his release on bail. The applicant appellant has been convicted by a judgment in order sorry, the applicant appellant has
22
preferred that
2020.
accompanying criminal appeal number so and so against the judgment in order dated 22/12/2022 passed by the Court of Learned, additional session judge Gulagat, within bracket the trial court for short. In sessions case number 13 of 2018, posted by the judgment in order dated 22/12/2024, the applicant appellant has been convicted for the offense under section 302 IPC, and he has been sentenced to undergo imprisonment for life and to pay a fine of rupees 10,000, with default stipulation. The paper book has already been prepared, on perusal. On privacy perusal of the testimony of the prosecution witnesses and the medical evidence. With the autopsy report here,
Lordship.
52.
Postmortem report, Lordship,
The-
52.
It is noticed that the disease died of a stem injury. Full stop. The trial court has opined that the date of the disease was a homicidal one. Full stop. Two prosecution witnesses had claimed to have witnessed the incident. Full stop. Mr. Chaudhary, Mr. Chaudhary, Learned Counsel for the applicant appellant has submitted that there are inconsistencies in the prosecution evidence. And the inconsistencies are material. Better. For consideration of an application, though the state has not filed any objection. Among we've gone through the contents of the we have gone through the evidence to materials on record. Available in the paperwork, post of foreign application and standard paragraphs. Having regard to the eyewitness accounts, having a privacy account of the, having regard to the eyewitness accounts and the medical evidence on record, we have the considered view that it's the the instant application is applicant has not without a bias, yes, for suspension sentence. So since the application is rejected, the appeal. Part Mr. Chaudhary, Learned Legal Counsel Board appellant, and Ms. S.H. Boda, Learned Additional Public Prosecutor for the respondent state post up. As the paper book is ready, office to list the appeal in the hearing list commencing from 14th July 2025.
Problem.
Item number 12.
Okay. E. Ahmed, Learned Counsel for the appellant, and Mr. R. Kaushik, Learned Additional Public Prosecutor for the respondent number 1 from the state of Assam. Post up. Where was the even directed to the 3 steps?
Yeah, we have taken lots.
Huh? No
We have-
step.
There is.
3 steps for notice has not been reached yet in the concern section.
With that acceptance probably it is there, and in the website also I have checked that one documents is shown.
But
as
no,
acceptance.
office notice 3/6/2025.
I will take a first step in that case.
Take 3 steps then. Then pays the office note dated 3/6/2025. Full stop. Mr. Amit Leonard, Counsel for the appellant, shall take 3 steps for service of notice on the respondent number 2 informant in terms of the practice direction. So and so. Mr. Kaushik Leonard, additional public prosecutor, shall obtain a report as regards service of notice upon the respondent number 2 informant from the officer in charge.
Officer in charge. Bukajan PO,
Bukajan Police Station
Lordship.
by the next state of list. Here's the case after police.
Okay.
Number 13.
Very good.
Yes,
There was a delay of filing of the appeal, my lord.
yes. No objection. All right. Mr. P. Kotogi, Learned Counsel for the applicant appellant. Mr. R. Kaushik, Learned Additional Public Prosecutor for the opposite party number 1, State of Assam. And Ms. M. Borman, Learned Legal Aid Counsel for the opposite party number 2. That's informant. Also. The instant application under section 5 of the limitation act 1963 is preferred, seeking condonation of delay of 423 days in preferring the accompanying criminal appeal, which is yet to be numbered and registered, full stop. The accompanying criminal appeal is preferred. Under section 415 BMSS to a sale. Oh. There was, a sale judgment, an order, dated 30/01/2023, passed by the Court of Learned Additional Session Judge cum Special Judge POCSO within bracket, comma Sipsagon, within bracket, the special court for short. In special, within bracket, POCSO case number 37 of 2022. Close stop. By the judgment and order dated 30/01/2023, comma, the applicant has been convicted for the offense under section
6.
Section 6, comma, POCSO Act. And he has been sentenced. Oh, section 6, POCSO Act
Yes.
and
And
in the section 376,
360.
within bracket 3, comma, IPC. So in view of section 42, comma, POCSO Act, the applicant is 376, 3, দুইটাতে confusion. Sentence is at 6, sir.
a higher one has been taken.
And 366 also,
Yes. 360 is also 10 years.
in view of section 42. POCSO Act, the applicant has been sentenced to undergo
Years.
rigorous imprisonment of 20 years and to pay a fine of rupees 10,000. Comma with default stipulation. Close stop. In addition, comma, the applicant has also been convicted under section 366 IPC. And he has been sentenced to undergo rigorous imprisonment of 10 years and to pay a fine of rupees 5,000 with default stipulations. Stop. Both the sentences are ordered to run concurrently. Close stop. Para. We have gone through the statements and environments made
Paragraph 6 and 7.
and the instant in application, more particularly, comma, paragraph 6 and 7 thereof. Full stop. Para.
His father expired, my lord, and his mother is a maid servant, my lord.
Para nine.
And then this one also.
It is averred. Where father expired?
You'll also,
Where did you say?
there, paragraph 6, my lord. On 27/7/23, I am.
It is averred that
I
after the impugned judgment, an order of conviction and sentence, comma, the applicant has lost his father as his father breathed his last on 27/7/2023. First, any plea of juvenility
financial problem, my lord. And he has
due to the loss,
tries to work as a maid
due
servant.
to expiry, demise of his
And
father, comma, the applicant. It is stated that due to demise of his father, comma, the applicant ran into financial difficulties and which has resulted in deferring the appeals, which delay goes on.
Recently, Supreme Court also, my lord, in similar
Where?
case, has 1,000 days delay, my lord, has confirmed.
Mr. Kaushik, learned additional public prosecutor, and Ms. Mia, sorry, Barman, learned additional public prosecutor. Sorry, not in legal counsel. Appearing for opposite party number 2, comma, less informant, apparently submitted that the submitted that they have no objection if the period of delay is condoned and the criminal appeal is hard on merits. Full stop.
There was a
So, yeah,
recent, Your Lordship, there was a recent.
having regard to the statements and amendments made the instant application and the region shown for delay, we have the considered view that the applicant has been able to show explain the period of delay showing sufficient cause. We are of the further view that since the applicant has been sentenced to undergo 20 years of rigorous imprisonment, rigorous, comma, interest of justice, better observed, comma, if the connected criminal appeal is hard on merits after condoning the period of delay of 400 days, close to. It is it has been emphasized that substantial justice being paramount and pivotal, the technical considerations should not be given undue and uncalled for emphasis, and no presumption can be attached to deliberate causation of delay. Full stop. It is further emphasized that a liberal approach has to be followed unless there is gross negligence on the part of the applicant. Full stop. In view of the above, the instant application seeking condonation of delay of 423 days in preparing the accompanying criminal appeal is allowed. Full stop. The registry to register the connected accompanying criminal appeal and thereafter come out to release the case partition.
So, the right to appeal has come to expensive definition of Article 21. Isn't that when? It's, I think in my matter also can.
So thereafter come out to release the appeal for admission.
Put in 1,600 days.
Banjara.
Paragraph 6, my lord, that was stated that.
Very-
Number 14.
offense
My lord, offense 20B2C, my lord, NDPS.
twenty B,
Roman 2.
okay,
capital C.
NDPS,
My lord,
NDPS,
NDPS, my lord, 25 days delay, my lord.
heard
S Nawaz, my lord.
Mr. S. Nawaz, Land Council for the applicant appellate. And Mr. R. Kosik, learned additional public prosecutor for the opposite party. Number one, opposite party, State of Assam. First of, the instant application under section 5 of the Limitation Act 1963 is preferred, seeking condonation of delay of 25 days in preparing the accompanying criminal appeal. First of, the applicant as the appellant has preferred the accompanying criminal appeal under section 415 within bracket 2B and SS against a judgment and order. Same date, sentence?
Same day.
Dated 5/2/2025, passed by the Court of Learned Special Judge Lakhimpur at North Lakhimpur in special within bracket NDPS case number 18 of 2021, posted by the judgment and order dated so and so, the applicant has been sentenced,
Page
has been
24.
convicted under section
Page 24. my lord.
page 24.
24.
Appeal.
Appeal, my lord. Page
Appeal
24.
no,
It
has
starts
been
from the-
convicted. One
One has been acquitted and
Okay.
two has been
has
convicted.
been convicted for the offense under section 20 within bracket small c
Also,
and read with section 29.
29. But my lord, in the judgment, it is been specified as 20B2C of the NDPS.
Where is that page?
Page
Paragraph,
24.
paragraph, paragraph.
24, my lord, para 40, 23, my lord, para 42.
Para 42.
42. Continues to page 24, my lord.
Has been sent, has been convicted for the offense under section 20 within bracket small b, within bracket small Roman 2, within bracket capital C of the Narcotic Drugs and Psychotropic Substances Act 1985, and he has been sentenced to undergo rigorous imprisonment for 12 years and to pay a fine of ₹1 lakh, with default stipulation. So we have gone through the statements and affirmations made in the instant application, more particularly, paragraph
Paragraph number 5 onwards, now. 5 to
5 onwards,
5 to 13. my lord.
5 to 13. Full stop. Mr. Kosik, query submitted since the period of delay is only 25 days, the interest of, query submitted that since the period of delay is 25 days, the delay can be condoned in order to hear the accompanying criminal appeal on merits. So, I mean, regard to the statements and environments made in the instant application, more particularly, not like, we have to consider view that the applicant has been able to explain the period of delay of 25 days, showing sufficient cause. Moreover, interest of justice will be better since the applicant has been sentenced to undergo 12 years. The interest of justice will be better subserved if the accompanying criminal appeal is heard on merits. Accordingly, the instant application seeking condonation of delay of 25 days in preferring the accompanying criminal appeal stands condoned. Raised fee to register the accompanying criminal appeal and thereafter to release the case appeal for admission.
I'm deeply obliged.
Subdivision is for hearing. Item number 18.
Material. Yes,
Here,
not much, short.
here, the PW one,
Huh.
I think I've seen it yesterday, Said I did.
PW1, I know the accused Megha Tibul at the top. I was working as teacher at Gita Ashram. The incident occurred 16/9/94. That day, I was at the residence of Gita Ashram. During the incident, I went to bed after taking leave at 30 p.m. I have heard loud sound asking Ashram Pura. And when I went out at the moment, the accused came to me and told that he killed Ashram Pura. Here, the accused told him that he killed the Ashram Pura. And I spoken to him, the cook in the Ashram Pura. Further, the accused told that the deceased was killed with Ural Madi on the road heading to Gita Ashram. Whether this person stays in Gita Ashram. The incident occurred near Gita Ashram. I informed Superintendent of Hostel Pramod Lalai and he came along with some local boys and we went to the spot. The accused was also present with him. Deceased was lying on the ground. We found him injured on the head. Blood came out and injured portion. He didn't die in that spot, died later. The accused explained that he killed with Ural Madi. Then we surrounded the deceased, took him to hospital, further treatment. This is the extrajudicial completion made before PW1. At that time, it was not there. Also waiting for 2-3 hours, I left the hospital. On the next day, I heard the Ashram Pura died. The accused stayed at his home. He stayed at his home. He didn't went to a hospital. In the meantime, Pramod Lala submitted an Edahan and police went to the spot and inquired the case and arrested the accused, Megha Tibul, who confessed his guilt before the police. The Ural Madi was brought to the police and seized it. Ural Madi was identified as produced for the court today, but I didn't sign that seizure. Now proceed. The accused residents are quartered near to our school. Basically, they stay nearby. I did not know the quarrel between them earlier. I didn't heard any quarrel earlier. The victim went to the house of the accused. The accused asked the victim to wait, but the victim didn't wait. So the accused followed the victim, killed the victim as it was victim was a Subhadhara. This is his version. During there was humor and hue and crisis around and hue and crisis around before to catch the Subhadhara. The incident was accidentally, I suppose. Had the victim has not silly at the other order of his house at night, the incident could not have been occurred as such. The accused told him that victim was
This part, where from he is saying? This cross part.
had the victim
What
was
is his source of knowledge?
this person,
Cross part.
cross person. And this is his person, and it seems
His person. He
That-
did not see the
He didn't see the
incident of
incident.
assault,
my lord.
right? This PW1
Yes,
did not see the incident of assault.
yes,
In the chief, he had said this much, that accused told him that he killed
Kill.
with Ural Madi,
well,
right? This part, where from he is saying,
but even if we exclude this part,
cross part.
cross part, my lord, this person especially,
The
That the
victim
victim
went to
was-
the house of the accused
my lord,
and eligible. Victim asked, the accused asked the victim to wait
wait,
because there was no dying declaration,
so then,
right? The accused asked the victim to wait, but the victim did not wait.
my lord,
The source of his knowledge, right, about this part.
my lord,
Then so the accused followed the victim
my lord.
and killed the victim, as if the victim was Hopadhara.
But
This part,
this part,
source. During that, there was humor and hue and cries around Diffu to catch the Supadhara.
my lord,
The incident was accidentally, I suppose. Suppose,
suppose,
thinking.
maybe,
Had the victim been not silly, was not silly, as at the order of his house, I don't know, at night, the incident could not have occurred.
yes, sir,
So it is his opinion. Opinion and the other part, source of knowledge, because the victim was not in a position to speak perhaps, but he did not say that the victim had told him.
this person,
Then the extrajudicial confession is that he killed Killed.
He killed.
He did not say injured. He killed with Huralmari.
No,
That is only one.
my lord. That is one, because here, my lord, it was not the first portion, the deceased was lying on the ground because the person was lying on the ground after the assault. So it might have, because the heat of movement, he might have thought that the person has already died because he was unconscious. That PW, one of that police officer also stated that.
So he was not in a proper state of mind.
My lord, he.
Accused. Accused has to be in a proper state of mind. Which state of mind?
My lord, and here, the first portion, I have heard the
Mr.
loud function
Kaushik,
in.
you have been making the trial a protracted one since 1994 to 2020.
My lord,
You are a state. You are running a trial
my lord.
from 1994 to 2020. That should comment. Article 21. Right to have an expeditious and speedy trial is part of Article 21. You had done. And by that, the memory of the others, see, these were examined in 2000 perhaps, 2004, after 10 years. These 1, 2, and 3, perhaps, 2004. And see the next witness, PW4, in the year 2019. After a gap of 16 years, 15 years. It is a protracted trial. And with this, only the extrajudicial confession can be made the basis of conviction.
Here, the humble submission, the extrajudicial confession, because going by the, I'll leave aside the statement of PW3 as seems to say years. 3 years. PW1, PW2. They never, but it has not come to light that there is anything or any.
No animosity, okay.
Any motive that they could indicate.
But what relationship also he had to confide to them.
Well,
There has to be some also confidence of the accused to confide in a person, to make extra judicial confession. What kind of relationship these two had?
They are neighbors. They are neighbors, my lord, and we say village people, my lord, they have a very close bond among them. And the situation is such that, my lord, the accused after, because the word of Asambura, and going at that word, it will, my lord, forward with the judicial confession. Here he said that he asked the Asambura to stop, then he didn't stop, then he killed him. So hearing that sound, initially PW1 heard that sound, then he came out. And this conduct of the accused.
Medical or not medical? LCR or something. LCR or medical mistakes.
Oh, please submit.
My lord, the conduct of the accused immediately after the incident, he immediately came running to this person. He made this extrajudicial confession, PW1, PW2. coupled with the fact that the Uralmari has been recovered from this place. And these questions were put to him by the Hiranshi, my lord. He didn't give any explanation.
Right. Firstly, it is a case of circumstantial evidence. And your events are 164 confessional statement. And the next one is extrajudicial confession of 1 and 2, PW 1 and 2. Other than that, what are the connecting factors?
Connecting factors,
Uralmari is not a connecting factor.
the medical evidence,
Huh?
medical evidence.
Then PW says blood was, he had seen blood. I am looking at the medical evidence, there is no question of blood.
But the injury,
Whether he is saying truth. I have seen the injury. That is why I have called for the medical
yes,
dictionary. Internal, nothing external, sir.
The skull was broken.
broken.
The skull was,
Skull was broken,
and
but
several.
he saw blood.
There was
PW2.
blood was.
Blood was coming out from head injury. Now we have seen in the medical report. Doctor. Intracranial injuries. Hematoma. That needs corroboration.
But here, because that was the plan of the, obviously, my lord, the head was, the multiple injury as per this medical report. Because multiple cranial bone fracture.
Cranial bone, temporal bone.
Exactly. There might be some blood in the spot, my lord. Because head injury is the major injury.
Not say by, we will not go by might be, maybe. Other than extrajudicial conviction, what do you have? This just because he has died, homicidal death, these all are to be connected. Otherwise, extrajudicial confession without any corroboration is a weak kind of evidence. Yes, it is true. Even on the basis of extrajudicial confession can be done. Conviction can be resulted. But question is that whether he is in a fit state of mind also. And you have not, which is the place where it had taken place, everything has to be proved. And where from the Uralmari was, he had handed over.
Here,
He had handed over. Somebody said, let us see.
by the police officer.
Let us see one by one, then if you are so hell-bent up, let us see.
The base 16, my lord.
No, one by one, we'll go check one by one. Let us see Uralmari. What does he say? PW1. PW 3. He said with a lathi. Page 13.
Yes, police.
Told to police. It was elicited from PW4 that such injuries can be sustained by falling on hard surface from a high place. Alternative possibilities. From PW5, it looks like the injured was in an unconscious state.
Yes.
Nobody has said that he was in a position to speak. So question of making any, conveying any information regarding the assailant is out of question. Nobody has
Okay.
said. Now the IO, page 16. I then went to Meghatimung's house, situated near the place of occurrence, and seized the wooden Ural. Now come back to PW1 and 2. They are so truthful. PW1. The Uralmari was brought to the police and seized it. Right?
Yes.
Now PW2. The Uralmari was brought by the accused and seized by police. IO. I then went to Meghatimung's house situated near the place of occurrence and seized the Ural from his house. And he has also concluded that was used in the accident. Seizure list. Let us see the seizure list.
Page 14. Possession.
Possession. But his statement is, I then went to Meghatimung's house, contrary to PW1 and 2. It was brought to police, according to PW1 and 2. PW says it's brought by accused, handed over. He said he went there and seized it from his house.
The fact
Is
remains
it not?
is from,
Huh?
but the fact remains because
Oh,
it's from
fact,
possession of.
yes, yes.
That
Now
is-
let us see the name of the witnesses. PW1. What is his name? Prabodh Chandra Bora. Is it a seizure witness? No. PW2. Is it a seizure witness? Yes. Then his statement is completely contrary. Is it not? Uralmari was brought by accused and seized by the police. Went to, well, present in this, went to police. So, possession.
Possession from.
Possession is what possession? Found inside the house. Hematoma. It is of page 44. Each stitch has an yes, each stitch to them.
No speech.
No stitch. Page 44. Now, what is the law regarding retracted extrajudicial confession? Now,
And it is made in the United States.
then also,
United States made up.
then also.
And another thing yesterday, Lordship asked me, it's very wrong here, but the judicial confession, page 60. Judicial confession. Your Lordship was pointing out that 281 code. Here, can we see, my lord? ROAC. Read over and accepted as final. So it was read over to him. He accepted.
An illiterate man,
My lord.
the magistrate, writing in English, read over and accepted. What he read over?
Why not that treated is that even to not bring the crime, never.
Not required. Firstly, it is his solemn duty. So far as 164 recording is concerned, he has to abide by all. Question of prejudice is not required. Firstly, whether he had complied with everything or not. A man giving thumb impression. A person writing in English, recording the judicial confession in English. Did he use any interpreter? Read over and accepted correct. Firstly, what he read over? What he read over, sir? English. English read over.
My lord.
And a man giving thumb impression. He understood English.
The statement, he made it in Assamese, he wrote it in English.
So if he knows Assamese, he should have written it in Assamese.
If, right now I don't have that, but if it is spoken in a language and written in a different language, that is a curable defect.
Huh?
That is a curable defect.
Curable defect, 463. You're making this statement responsibly or irresponsibly?
I'm just.
No. Make your statement responsibly. We're ready to find out section 463. Section 463. Read 463.
Non-compliance with provisions of.
So it is for the court.
It's for the-
And Supreme Court has said non-compliance. And subsection 2. The provisions of this section apply to courts of appeal.
the reference
And it speaks about section 164 and section 281. Right? Now again 281.
court.
The record shall be shown or read to the accused, this part, second part. If he does not understand the language in which it is written, shall be interpreted to him in a language which he understands. Where is the reflection?
He shall be at liberty to experiment. and
Then what he has written, what he has said, there could be vast difference. And 1/6 Nazir Ahmed, it is holding the field since 1936. This part is not there. If you can still show, because under 463, we have to see whether there is the reflection, because any non-compliance may prejudice. Yes, I could understand a graduate.
Here is a completely rejected.
Things could have been different. He knows English and he has been read in English. He has been yes, I have read this in English. Okay. But if he is this man, what is the content? What is the content, sir? What is the content of the extrajudicial confession?
Page 60.
Page 60.
60. Leave apart truthfulness. If he conveys this thing in English, whether he was in a position to understand this, Megha Timung, read over an RONAC,
Going by the
and secondly, what Miss Bhuya, Sarkaria and all, and
Sankati.
other many other,
Ratan Lal, Sawan Singh, Ratan Singh.
Sarwan Singh, Alok. Then if we test, even if we keep aside two tests, first test, then second test. If it crosses first test, then second test. The other was this, he fell down immediately. Then I, along with 4 teachers of the ashram, brought the victim to Diffu Civil Hospital and got him admitted there at 9:30. Then I came back home. And this part, nobody said. And whatever extrajudicial are retracted, extrajudicial confession.
In the Somalia itself, there are 51 regarding official confession.
Huh? Sarwan. Yes, Sonkoria. 78 3 SSC. Which paragraph?
51.
Okay. This is regarding which point?
Retracted, but I think this is regarding official confession.
This is judicial. Retracted extrajudicial. It is there somewhere, first test, second test. Where is the first test, second test? Somewhere I have seen first test and second test. Sarwan or Songkori? Songkoria, pair 23. The first test is admissibility in evidence. Your statement in negation, this should be taken now as nearly as portion of the accused. Whenever question is to be put into a record together with the answer. It is the norm for the statements proceeds. Begins. Technically, sir. জয়চন্দ্রকে প্রয়োজন জয়চন্দ্র বুঝবে জয়চন্দ্র 2004, 2001, Yeah, the রাখিলে যে আসলে খেলেন সাইড আসলো Yes, Mr. Kosik, where it is reflected otherwise, because here deposed 3 months, 3 hours reflection time was given. How and from where it can be seen?
It's only on the evidence.
In his testimony, but it has to be in black and white.
Yes.
From where it can be seen?
Statement of the.
That I have seen.
Yes, sir. Apart from the.
At that time, he is under the guidance of the PP.
At page 57,
That I know, but where from it is?
at page 57, madam.
It is Hashim. He.
At page 57, if you also will see, in the printed format, it is there,
Page 27,
57.
57. Printed from which one?
On the left-hand corner, serial number
Being
3.
taken. Oh, that I have
Third,
not.
He shall be
actually
given at
each
least
of the-
3 hours for reflection, during which he shall not be given be in contact with any police officer and so on.
Where is the 3 hours time?
It is there. He shall be given at least 3 hours time.
Which one? Which part?
Page 57, serial number 3 on the left-hand side column. The requirement is
At
in
what
the-
time he was produced?
It's not given.
Courts
Right hand side.
was brought. The time of production?
He should have written here. It's not there.
Hmm?
It's the blank has not been filled up.
Huh?
On the right-hand corner at page 57,
I was, page 50.
7,
Uh,
right-hand column,
the
first place.
state should ascertain when the alleged offence was committed by coercion as the
It begins with page 56, madam.
56. Hmm.
The accused Miku Timung is brought, right-hand side, madam, is brought by the police constable before me at my court on 19th September at 3 p.m.
3 p.m.
to give his confession recording.
3 p.m.
3 p.m. Now, when he
Then
reflection
3
started,
plus 3?
6,
6.
but that is not written. In the second page, page 57, it should have been written that first placed under observation from so and so time. When he was arrested.
Find out if it is 6 p.m.
It is not moved.
Very sincere. Man. Criminal rules and practice for organism. No?
Yes.
One more query. Section 164, subsection 4. This memorandum, whether it is a requirement to make the same in its own handwriting, or it can be typed in it can be signed in a
Format. It is given in the
format.
format it is given, he has signed it.
The format is given, that I know.
Whether it
That I
is to
know.
be written. It is to
I'm
be.
just asking the law.
Well, here, for Lordship kindly produce page 61.
Section 164(4).
Any such confession shall be recorded in a manner provided in section 280. For recording the examination of accused person shall be signed by the person making the confession.
No, 164, subsection 4.
Different, I'm reading 164 sub.
Hmm? No, I have 164, subsection 4. That memorandum. this subsection 4, I'm asking this memorandum, whether signing in the type format fulfills the requirement or not. That is what I am asking. Have you understood my query? Because it says magistrate shall make a memorandum at the foot of such record to the following effect. So I am just asking that whether this is in a, because otherwise format is required. There, you sign it. That is the requirement. Or shall make a memorandum means magistrate in his own handwriting has to write. Because these are very solemn thing. Any non-compliance may affect. That is what I am. Section. We don't go anything. Need enough again. Need enough again. We don't pay him. Even killing them. We'll look into that aspect then.
If I
Anything?
may place a decision on that one. 2002 volume 8 SSC, page 447. It was under TADA, section 15. There, 281, 164.4 or interlinked. I'll just place the section 15. The recording of confession made to the police officer.
Bit louder.
The recording of confession made to the police officer. A confession made by a person before a police officer and recorded by such police officer under section 15 of the Act shall
That is
invariably,
police officer.
but it is interlinked. Just please. Of the Act shall invariably be recorded in the language in which such confession is made, and if that is not practicable, the language used by such police officer or official purposes or in the language of the designated court, and it shall form part of the record. 15.2. The confession so recorded shall be shown, read, or played back to the person concerned, and if he does not understand the language in which it is recorded, it shall be interpreted to him in a language which he understands, and he shall be at liberty to explain or add to his confession. This is 281. Then
That part I am clear.
that part is clear.
Now, at the foot, the memorandum at the foot.
No.
There is
Paragraph
absolute
29.
non-compliance regarding 281 that read over. That I'm quite clear.
Paragraph
Let
21.
me
Paragraph
convey it
21.
to you.
Thus, the fate of not only the accused but the co-accused as well as hinges on the confessional statement recorded by the police officer under section 15. Such a statement cannot be recorded in a mechanical manner. All the safeguards provided in the Act and the rules have to be strictly adhered to. There can be no room for latitude in the matter and the manner of recording the confessional statement. Any material discrepancy will be fatal unless satisfactorily explained by the prosecution. The burden of proving the confessional statement always remains on the prosecution. It is for
I
the
think the
prosecutor.
specific answer I have.
No.
The answer is that magistrate has to write in his own handwriting. The answer is given by AI. But I am trying to find out the logical
AI,
thing.
but I have not followed the,
That is what I am saying. That is what I am saying. That is why I am trying to find out, is there any authority or not?
If I may place a decision of this court, my lord, dealing bench.
Your Viceman, in page 61, mention is regarding one, High Court General Rules and Circular Order.
That I have tried to
Chapter
find
1,
out, sir.
Holder Round.
I have also tried to find out.
Take up his days, the form is not available anywhere.
Mm.
Recording.
My lord, same place. The executive magistrate is the same person. Here the incident took place in 1993 in our.
Which
case,
part? Which part?
Par-
Regarding the,
Paragraph 22.
no,
page
you are repeating that same language. So I am on the memorandum at the foot.
at the foot, my lord.
Where it is.
In this case also, he was taken in the,
So tell me, is it on the memorandum at the foot?
on the memorandum. it's-
No, then don't
Right.
repeat. I am quite clear about it.
Right.
That I am quite clear about it.
What is it?
Regarding
Regarding
memo-
so that it could be in a printed form or it could be written by the magistrate.
Right? That is what I am trying to find out. A Kartik Subrahmanyam ka last name is K-A-R-T-I-K. Kartik. Chakravarty, Chakravarty. What is?
It's from 2018.
Huh?
The planting capabilities have been issued from 2018.
Whether it contains or not, I don't know. It is showing. If you- Hey, what to- people- If he comes,
They are in planting.
or there is a full bench judgment. And there is a different context.
Who is magistrate?
Huh? Huh. But judicial power was at that time was given to the Caribbean authority, so we should not deal upon that. Whether anything regarding memorandum, I think this judgment we have dealt with in another judgment. Not regarding memorandum. Shall make, the magistrate shall make. So whether that making can be on the basis of a type form, that is what I am looking into.
But that type copy is given in a form.
No, it requires non-mechanical way of record. Type copy means mechanical. That is what I am looking for. Because that means personal involvement of the making an undertaking in his own handwriting. That makes the difference. And I'm quite sure it is to be written in his own handwriting. Not on prescribed form. I am not finding the Guwahati High Court rules.
That is not a such number of times. So, I request you. Take consideration, not in the high court, it's not the criminal court.
Because this format where he is recording the 164 statement, that is somewhat. Anyway, that's 281. See, there is no compliance.
281.
4. ROAC. That there is law. Then we'll deal with the extrajudicial conclusion. And the protracted trial also.
But Mayor, can it be fixed on Monday? Because
Huh?
second half,
I'll dictate or you want Monday. P. Kotogi's case was there.
Yes. We are allowed, I think, something. Not, absolutely nothing.
That is why I did not entertain the bail application, just because I have not found anything. Like in the Kuntari. 96. P. Kotogi too long. P. Kotogi too long. Hearing.
And with juvenility, statute.
Okay, let us see, Mr. We'll put it on 9. If not possible, we'll take up on some other day. Depends on the business of the court. But I am just looking into that foot at the foot.
no, I will also look into if I get some.
Please find out. And I'll in the meantime ask the registry. What is the format regarding 164?
During my this 164 goes done. Because non-compliance.
We'll look into that.
Otherwise, from the extrajudicial confession.
We'll look whether it can be a standalone evidence to convict the accused. That we'll look into it. We are examining that. But it needs corroboration. Whether corroboration, finding an Uralmari in his house. If you, that locus classicus, Pulukuri or what, section 27, finding a dagger or knife in the house, there is no disclosure statement, absolutely nothing. Uralmari is available everywhere. You have to connect that Uralmari with the crime. That is your duty. Neither accused duty nor the court's duty. You have to connect. Uralmari is everywhere. Dao is everywhere. And it is not that it was found near the body of the injured. It was at his home. Huh? Uralmari. May not be in metro, but it is still available in my house. And Uralmari is available, maybe not Dheki in poor people's house, but Dheki is also available everywhere. It is not very costly. Uralmari is not very costly. Have you gone to village?
Our Ural as well as big.
This much size.
Now it is a small iron.
My landowner also owns, but now they are.
In school days, I have been made to do Uralmari also
Yes, yes. Guys,
during Bihu time.
Lordship.
Okay, Monday.
Article 16, if Lordship permit me.
Huh?
next-
You want to do it?
No, no, next day.
Huh?
Next day.
We are available. Next day. And we cannot fix, we have fixed many matters. We'll adjust. Okay, on the prayer of Mr. Dr. B.N. Goyal and council, amicus. Amicus. Likhi diyo. On the prayer of Dr. B.N. Goyal and amicus for the appellant, the matter stands as one for 1 week. Be present. That part only. Memorandum at the foot. That is one. Whatever you can find on extrajudicial confession. So, Mr. P. Prasad, amicus brief for the appellant and as requested by Mr. P. Prasad, amicus brief for the appellant, Mr. R. Kosi. Then it's additional public prosecutor. Is the case on Monday. Monday. We should come away.
Lordship.
For pronouncement of judgment, item 1. Criminal appeal sale 6 of 22. Saddam Rava versus State of Assam.
Instant criminal appeal is devoid of merit and the same deserves to be dismissed.
Not audible.
Is dismissed, criminal appeal is dismissed. Am I audible?
Criminal appeal is dismissed.
Dismissed.
Remove.
Item number 2. Criminal appeal jail 73 of 20. Sontok Hans versus State of Assam.
The criminal appeal stands partly allowed to the extent indicated above. Therefore, taking all the facts and circumstances into consideration, we are of the considered view that interest of justice will be subserved if maintaining the conviction under section 326 IPC and section 307 IPC passed by the learned trial court. The sentences imposed under the said offences are modified and reduced to 7 years each respectively. The fine amounts imposed under section 326 IPC and section 307 IPC are to be maintained along with the default stipulations. To stop the conviction and sentence passed under section 324 IPC for causing hurt to PW2 is not to be disturbed. It is ordered accordingly. All the sentences are to run concurrently.